Well, this has been a huge undertaking for all of us.
Oh, I know it has, Your Honor. And it's
Hey,
barely begun.
Danielle, I
I'm
just
sorry.
wanted to let you know we're about to start going live.
Okay, great. Thank you.
Morning or afternoon.
Oh,
Good afternoon. All right, good afternoon, everyone. I think it's 2 o'clock. I think it's a good time to start on time. I'm Jay Corpening. I'm one of the co-chairs of the COVID-19 task force, along with Senior Resident Superior Court Judge Don Bridges. On behalf of Judge Bridges and I, welcome to the second meeting of the COVID-19 task force. I'll remind you at the outset that this is a meeting that is subject to the open meetings law recently amended. So we have members of the public who are listening in, and this is being live streamed on nccourts.gov. We're going to begin with a roll call, and so I'll ask Emily Meda to conduct the roll call of members who are present. I'll also ask members during the meeting, anytime that you speak, please identify yourself, especially folks who perhaps called in on telephone or don't have their cameras activated. So Emily, will you call the roll, please?
Yes, sir. Judge Bridges, you're here.
Present.
Judge Corpening, you're also here.
Present.
Judge Shermans, are you on the line? We'll come back to Judge Shermans. Judge Benson?
Here.
Mr. West?
Here.
Mr. Evans?
Here.
Clerk Johnson?
Here.
Clerk Chingary?
Here.
Kinsley Craig?
I'm here.
Kelly Myers? We'll come back to Kelly. Mr. Cheek, are you on?
Yes, I'm here.
Jennifer Harjo, I think I heard you earlier. Jennifer Harjo? All right.
Yes, I am.
Mr. McCabe?
I'm present.
Mr. Harrison?
I'm here. Thank you.
Mr. Weed?
I'm here.
And Mr. Keister?
Here.
That's all of the members, Your Honor.
Emily, Kelly Myers is here. I was just muted.
Okay, great. Thank you. That's everyone, Judge Corpening.
Emily?
Thank you.
Yes.
Thank you very much.
Sorry, is Sherman's on? I didn't hear him reply.
I'm sorry?
Is Judge Sherman's on? I did not hear a reply from him.
Judge Shermans, are you on?
Okay, thank you.
I see him now. Judge Shermans, he just may not have his audio on yet.
Great, thank you.
And Clerk Chingary, I think I heard you. Is that correct?
Yes, I am here.
Okay, thank you. Now that concludes everyone, Judge Corpening.
Thank you very much, Emily. And I'd also like to welcome our folks who are participating in support roles from the School of Government, from Energy Defense Services, and from AOC. Our first order of business today is to approve the minutes from our May 1st meeting. The minutes were distributed electronically to you earlier. Any additions or corrections to the minutes?
This is Kelly Myers. I submitted one correction to Danielle Carmen earlier today to just correct my title as trial court administrator throughout.
And I have made that change, Kelly.
Thank
Thank you. You're welcome.
Thank you. Any other additions or corrections? Hearing none, is someone willing to make a motion to approve? And if you are, please state your name and the motion.
This is Robert Evans. I move to approve the minutes.
Patrick Weed, I second.
All right, motion's been made and seconded. Any further discussion? All right, we're going to do a roll call vote since this is an open meeting. So Emily, back to you for a roll call vote on the motion.
Judge Bridges,
Aye.
Judge Corpening,
Aye.
Judge Sermon,
Aye.
Judge Vincent, Mr. West,
Aye.
Mr. Evans,
Aye.
Clerk Johnson,
Aye.
Clerk Shingari,
Aye.
Kinsley Craig. Aye. Kelly Myers,
Aye.
Jason Cheek,
Aye.
Jennifer Harjo,
Aye.
Mr. McCabe,
Aye.
Mr. Harrison,
Aye.
Mr. Weed,
Aye.
Mr. Keister.
Aye.
That's everyone.
Thank you. The ayes have it. The minutes are approved. Our next item of business is to look at any recommendations we have as a task force for any additional extension or modification of the June 1 deadline. And Judge Bridges is going to facilitate the discussion on this issue. And so I will pass the meeting to you, Judge Bridges.
Thank you, Judge Corpening. Also wish to express appreciation for those of you who are able to get us some written reports back from your constituents in a very short time frame. Written reports have been very helpful, and we will talk about them some further, and also have an opportunity to receive any additional verbal reports that any of you have with regard to your external work groups or the other folks with whom you're consulting about suggestions in this area. First, to go back and briefly recap generally what our mission is with regard to possible additional deadline extensions and or clarifications. You'll recall that Chief Justice Beasley has issued a number of emergency directives that have addressed previously existing deadlines with regard to filings required to be done, and also acts that otherwise would have been required to have been done, or things that would have come due during the period between March 16th, 2020 and June 1st, 2020. Those deadlines have been extended. For the most part, those deadlines will now fall due on June 1st, 2020, unless otherwise extended or otherwise expressed by further emergency directives from the Chief Justice. So we have been asked to address a number of issues. First, should there be any further deadline extensions beyond June 1st, 2020? Second, if so, on what date or dates should the new deadlines now fall? And should those deadlines be in the form of a specific date, one hard and fast date for all previously existing deadlines that have been extended? Or should it be a series of rolling deadlines? Or should it be some combination thereof? I will mention parenthetically at this point, if you'll simply make a mental note, and we'll come back to a written report that we received from the family law practitioners with respect to concerns about further extensions of deadlines. Issue number 3 would be how would we go about articulating the rule to be applied to each category of deadlines, and specifically with respect to the fact that we're talking about both filings required to be made as well as acts required to be done. And with respect to the interplay between filings required and acts required to be done, if you all have handy, there is an email that was circulated from Matt Osborne dated May 4th, yesterday, specifically addressing directives from the Chief Justice on April 2nd and again this past Friday, May 1st, and some interpretations of how those directives would be applied, for example, with respect to payment of fines or other matters that would need to be done in compliance with court orders. And you can see by reviewing that email and that explanation just how complicated these matters get when we start dealing with the nuts and bolts of how to articulate the calculation of these deadlines. A couple of recurring points that I want to mention generally that can be gleaned from the suggestions that we have received and from the written reports. We've talked about in our previous meeting some of the competing concerns and some of the things that we hope to accomplish in whatever we do. Number one, and a recurring point that is made in these written reports that have come in, is the need for clarity in whatever we do. Under the best of circumstances, this is going to be a very confusing area for the people who come into our courts, for the practitioners that are involved in the day-to-day practice and in trying to comply with deadlines. So to the extent that is humanly possible, we need to try and frame our work in a way to express clarity as fully as possible. We talked at the last meeting also about a concern that many of the clerks have, and justifiably so, being concerned that if we set one specific date as a deadline for everything, that there's a possibility that may result in mass filings on or about that one day on which the new deadlines come due. So within that context, there have been a couple of suggestions that we may wish to incorporate into whatever action we finally take, and that is an encouragement to remind all practitioners and all litigants that while there may be a new deadline set at some point in time in the future, that is not the only day on which filings may occur. A gentle reminder that the courts are open and the litigants and the attorneys may and should start as soon as possible with their filings of documents or with their performance of acts that were otherwise required to be done on or before a specific date. And secondly, that with some notable exceptions, such as statute of limitations type deadlines, that local judges still retain authority to grant additional extensions of time as provided by law upon the showing of good cause or whatever the appropriate standard is for the granting of those additional deadlines, and that hopefully the local judges will exercise their discretion with regard to the dealing in those situations with those possible extensions. Now, I believe that we have received a number of written reports, including a report from the Conference of District Attorneys, a written report from Ms. Harjo on behalf of public defenders, as we have received a written report from the family law practitioners, and I believe we received a written report also from Mr. Weed on behalf of the criminal defense bar. So I want to give each of those groups an opportunity to weigh in on their specific written reports, as well as any other comments they wish to make in that regard. Now, I will say that in some of these written reports, you have addressed not only the issue of deadlines, but also other concerns, including best practices for health and safety as we expand upon present operations of the court and move back to full operations of the court. So at this time, keep in mind, please, that we're addressing primarily the concerns that we have about deadlines and the extended deadlines. So let's start with those groups from whom we have received written reports at this time. Mr. Weed, do you want to speak to the recommendations of your group? Is Mr. Weed available?
I'm sorry, I was talking with it on mute. I apologize. Excuse me. I would, in the responses that I've received on behalf of other criminal attorneys, especially criminal defense attorneys, I think regarding, first of all, the issue of clarity, criminal lawyers are wanting to see directives that apply consistently across the state so that counties and courts would not have the discretion to apply certain directives in different ways. I think I received more feedback related to some of the other topics that we're not covering at the moment, so I'll try to direct my comments in regard to the feedback I did receive and how that would apply to the current topic at hand. I think, and also in reviewing what family law sent out and some of the other information, perhaps ultimately a directive or series of directives that separate criminal law from family and other areas of civil law may be necessary. I think that from what I have received, having and going along with the idea of clarity, having one deadline for all filings related to criminal law would be beneficial rather than the rolling extensions of 30 days, 60 days. I think what criminal lawyers are concerned about in terms of moving too quickly going forward is that with representing individuals who are in many circumstances who are in custody and the difficulties in reaching those individuals over the last a couple of months in working with investigators and their inability to be out in the field as normal, extending all deadlines related to criminal law perhaps until Friday, July 31st, so approximately 60 days, I think would give criminal lawyers enough time to start getting back to going to jails, conferring with clients, going over issues that would need to be addressed in motions, responses to motions, filing motions such as motions to suppress, things that have been due over the last couple of months that would currently be due June 1st. That additional extension, I think, would be welcomed and would help to provide criminal lawyers with that additional time. And so I think that the desire for clarity, and I would recommend for criminal law having one deadline and having that extended out approximately 60 days.
All right. Ms. Harto, do you want to weigh in on that issue since you're in the same field?
Sure. I think what I will say is I would just concur. I don't reiterate everything that's been said, but from the criminal attorneys, I heard all of those same concerns. The only concern I did hear that was different than having a rolling date was the attorneys that handle criminal, family, estate. They suggested to me that it would be helpful to them to have rolling dates to the extent that in the different areas of law, there would be different time frames for when things were due, because they're also going back and meeting with different clients on different types of issues. and to have everything due at one particular date, they felt would be difficult. But for the most part, I think I will just say I concur with what was said.
I'm not sure I understand fully what you're talking about in the category of rolling deadlines. Now you're talking about matters other than criminal cases.
I am. And those suggestions came from the lawyers that practiced in various different areas. So if they practiced in criminal law and family law and perhaps did estates, and primarily these were attorneys that were in smaller, solo practices or smaller offices. And they just suggested that if they had one date where everything was due, no matter what type of matter, if we had just one deadline date for all matters, they indicated to me that would be difficult. But if we were talking about one particular date for certain areas, for certain matters in criminal law, maybe another date for family law, that is the type of, I guess, rolling or differentiated due dates or deadline dates that were proposed.
What do you all consider to be the significant categories of deadlines from the standpoint of a criminal defense attorney? Deadlines for filing pretrial motions, deadlines for filing notices, for example, a notice of an affirmative defense, deadline for responding to a reciprocal discovery request. Would those be examples of what you're talking about?
Yes.
Yes, yeah.
Are there other major categories that you all normally consider to be deadlines for a criminal defense attorney?
Well, Judge, one of the things that you mentioned in your responsive email to me was that what about the obligations that are due? And I think from that perspective, if we're just talking about obligations that are due from the clients, for instance, paying fees or paying costs or, certain, and I think that we've taken care of some of these obligations from the DMV with the governor's order. But those type of obligations would be something that maybe would be considered as well. Filing deadlines, I don't know that for criminal law, quite frankly, there are as many filing obligations other than dealing with what was said initially with experts. I think those type of obligations are issues that are going to take time for the lawyers as far as getting back into action.
I had some difficulty understanding some of what you were saying. Did I understand you to be recommending that the compliance aspect with regard to clients be handled on rolling deadlines rather than a specified date?
I think a specified date, whatever date we pick, if there's some time in consideration, is fine. Honestly, with those type of issues, they're going to probably have to be dealt with on a case-by-case basis in any event. Whenever a client appears in front of a judge, that if there's a reason the client hasn't complied, that reason is going to have to be given to the judge. And I don't know if there's any date that we can set specifically that will accommodate everybody.
Lee, do you have thoughts on that issue, on acts required to be done or compliance with existing orders?
No, I agree with what Jennifer said. I think clients are obviously, or individuals, defendants are obviously struggling right now with financial issues and inability to find work in some circumstances. So I agree with what Jennifer said. It is not going to be possible to find one date that's going to be a perfect situation for everyone, but I think that is also an area that acts to be done that needs to be extended. Another thing I think goes along with that for acts to be done would be requirements to do, for example, community service that can be ordered in some cases. And that is also, I think, proven to be very difficult, not only for individuals who may not be in a high-risk category, but those who are in a high-risk category, and being able to get out and get that done over the last 60 to 75 days. So an extension not only for monetary obligation, but other action funds such as community service, I think would be welcome as well.
Okay. Do we have any other suggestions from any member of the task force with respect to that area of practice? Are we overlooking any aspect as it affects the practice of criminal law or the enforcement of orders entered in criminal court? In particular, do we have anyone from the clerk's perspective or any of the judges that are seeing any other aspect of that area? All right, let's move on to talk then. We received a report from the district attorneys that was a very thorough, very well-reasoned report. But perhaps more of the focus of that report was related to some of the other issues rather than deadlines. What would the district attorneys like to say as to the possible extension of deadlines for filings or acts required to be done?
Billy, I'll defer to you since you were at the meeting on last Friday, but Judge, my thinking on that is in terms of acts to be done, I generally agree with the defense bar that there needs to be flexibility. And so those deadlines probably need to be more of a rolling type. And also maybe even some flexibility district to district. As for the filings, most of the dispositive type filings that occur at least in my opinion, in criminal court also attach with it the ability of a trial judge to grant relief where there is no gross negligence or omission. And so I guess if you set a hard deadline there, even in instances where there are still problems, you're going to have probably the ability for a judge to grant relief. I'm speaking for myself. I don't know whether or not Billy, the conference, would have a different view of that, but that's the way I see it.
Yeah, I agree with Robert. When we had our call Friday morning, which is unfortunately why I missed this group meeting on Friday, we really spent a lot of time talking about the continuation of grand juries or the resuming of grand juries for those districts that have not had them taking place during this pandemic period. And we also talked about the resumption of jury trials, and we gave 2 proposed dates for those. The grand juries resuming no later than June 1st, and the jury trials allowing to be calendared by the district attorneys beginning on August 3rd. But to the question about deadlines and that sort of thing, we did not have a lot of discussion about that. But I do think I can speak for the group when saying that I don't think there's going to be a lot of opposition on behalf of the district attorneys to any extension or rolling deadlines or anything like that. It was more discussion of when can we get started with court, at least on a limited basis, and resume jury trials, grand juries, and things like that. So I don't think we'd have any objection to whatever the task force and ultimately the Chief Justice would recommend as it regards to deadlines for filing.
All right. Thanks, gentlemen. Let's move over into the area of family law. And Wade Harrison provided us with a written report from that group. Mr. Harrison, are you with us? Do you care to comment further about your recommendations or those of your group in that regard?
Just first to, thank you. First to explain, we have pleading requirements for claims for alimony, child custody, child support, equitable distribution, divorce from bed and board, and then we're required, if those claims have already been filed, we're required to file a separate action for absolute divorce. The extension of all deadlines, the blanket extension of all deadlines, has primarily affected our practice area by extending deadlines for discovery responses, extending deadlines to make responsive pleadings like answers or counterclaims. But it's also had an effect on our ability to get absolute divorce judgments for our clients, because normally there's a 30-day window for a party to respond or answer a divorce complaint. And after that, our clients are eligible to move for summary judgment and have a summary non-evidentiary hearing and obtain the absolute divorce. The automatic extension has moved that deadline, and in order to get an absolute divorce, there has to be cooperation by the defendant, the non-claiming party. And a lot of times in family law situations, it's hard to get that kind of cooperation. Sometimes it's a financial matter, and sometimes it's just a matter of pure old spite. So what we're facing is, children are potentially being born out of the right wedlock, because people can't get divorced in time to remarry before the child is born. It complicates insurance coverage issues. It can even complicate the division of retirement plans. So that's one concern. The other concern is that family lawyers that I spoke to sort of feel like everything is stopped, and we're more interested in finding ways to get things started again, and start making some progress in some of these cases, and feel like extending the deadline would impede that. We don't really see a downside about not extending the deadline, because except in statute of limitations matters, our district court judges can ameliorate any unfairness that may result from strictly enforcing a deadline. On the statute of limitations and statute of repose issue, although many family lawyers practice in other areas, in family law, the marital torts are pretty much limited to alienation of affection and criminal conversation. There are some other marital torts, but they're not a big part of most of our folks' practice. So we just chose to stay on the sidelines as far as that issue is concerned, and let the lawyers that deal mostly in civil tort litigation deal with that. I think that does it, and thanks for your invitation to participate.
All right, thank you, sir. Mr. Harrison, are you the only person here from your area of practice among us today?
Well, I'm sure that there are people that are involved in the court system that have familiarity with family law, but to my knowledge, I'm the only one on the task force who specializes in it and pretty much exclusively practices family law.
All right. Well, here's my question for you. With regard to how we would express to the Chief Justice the specific wording of what she could do to accomplish these purposes, what do you envision could be done in that regard with respect to the currently existing deadlines?
Well, first of all, I'm trying very hard to understand and put myself in the role of lawyers that practice in other areas. So I don't disagree that there should be perhaps different rules with regard to criminal law for a lot of different reasons. But for purposes of family law, simply discontinuing the stay would accomplish what we're looking for. And you could describe the issues. There's a finite set of issues that would be affected. And I'd be happy to propose some language to the Chief Justice in that regard. But we're not asking for anything affirmative so much as to relieve us from the blanket extension order.
Well, let me ask perhaps that question, or maybe a different question in a different way. The Chief Justice has, in her most recent directives, has tweaked somewhat our way of doing business, particularly with regard to remote hearings, at least within the civil arena, by now saying, rather than requiring consent of all parties, that a judge may conduct a proceeding remotely, even without the express consent of all parties. And in other words, the presumption now would shift so that unless a party objects to a matter being heard remotely and shows good cause for it, the judge may proceed with that remote hearing. I'm wondering if your situation, rather than dealing with the problems your group is experiencing now, might be addressed through that sort of mechanism rather than trying to carve out specific language about the deadlines per se. Is that perhaps what we're talking about with regard to family law?
Well, that might meet one, I guess, one aspect of it. If there is a potential for a remote hearing and it requires someone to stand up and affirmatively object, then yeah, that would solve the problem. The problem with the blanket extension rule is if an answer to a divorce complaint is not due until July 1st, then the matter can't go forward until the answer is due, because the person has the right to make an answer. Similarly, if all discovery deadlines are extended until July 1st, automatically, then there really can't be any progress made in getting toward trial if attorneys who want to delay trial can simply not respond to the discovery and thereby prevent the other side from being prepared to go to trial. So again, the blanket extension doesn't fit very well in family law cases, and I couldn't find any support among the family law bar for extending the deadlines. So I think it would, speaking on family lawyers' behalf and certainly on my own behalf, I would suggest that the better approach for the Chief Justice would be to carve out family law, and because that would do really no harm as far as I can tell, and it would allow these cases to proceed that are in the discovery phase and in the pleading phase, and any aspects of unfairness could be dealt with by the district courts. I would also say that the recent pronouncement by the Chief Justice about mandatory remote hearings has been welcomed by the family law bar. However, it's only beginning to take effect, and it's taking effect somewhat unevenly across the state. So it's not a uniform solution all across the state.
What would be a good starting point for articulating how the Chief Justice might go about carving out a specific treatment for what's being done in family law?
Well, we've got a finite number of claims. The claim for absolute divorce could be exempted. The claims for responsive pleadings to alimony claims, to equitable distribution claims, to child custody and support claims. Although for a lot of those, there's almost a default objection built into the common law. We have a relatively confined practice area with a finite number of types of claims. And then, of course, discovery deadlines in family law cases. I think that would adequately describe the discovery deadlines. So, I mean, I can't sit here and draft it right now, but I can assure you and the Chief Justice that with a very short, within a very short matter of time, I can get some proposed language to you.
I would like to invite some of the district court judges who are with us today, if you're interested in doing so, to weigh in and provide your expertise in this area. If you were asked how to help us jumpstart the family law cases again, if you're doing it just in your own district, how would you go about doing that? If you had the power to write your own rules to get these cases going again under these circumstances, what would be the best way to do that?
This is Vincent. Can you hear me?
Yes, ma'am.
Yes, I don't mind weighing in with Mr. Harrison. We already have funds from remote hearings in Guilford County, and we've allowed an opportunity for attorneys to begin to have those during this month. And so, I don't mind contributing and consulting with Mr. Harrison if he's open for that.
I actually am very open to it, and I have been communicating with attorneys from, or at least one attorney from Guilford County, and have gotten a copy of your orders regarding scheduling. And I think I commend you for getting things started, and I'd be happy to work with you.
Thank you. We're going to have a remote calendar hopefully as well coming up, and so I can talk to you about that as well.
I think that's scheduled for either the 14th or the 18th. I'm looking forward to hearing about how that works. Yeah.
Yes. Okay. Thank you.
This is Jay Corpening. I spent about an hour with my family court administrator this morning talking about this issue, and she has spent a lot of time communicating with our family law bar in New Hanover and to some extent in Pender County. And they share the same sense of urgency that Mr. Harrison does to get the ball rolling again in family law cases and domestic cases, because with some exceptions, we're at a halt for doing a lot of things in family law cases, and so the folks from my community weighed in and asked that there not be any additional extension on family law cases. And I agree with Mr. Harrison. There's a finite number of claims that we can identify and say that, but at least in that area of cases, they were requesting no extension of time. While I'm speaking, I did get a variety of opinions from Chief District Court judges that I reached out to yesterday morning to get their input, and some favored fixed deadline, some favored some fixed deadline with local authority to extend deadlines. Some favored rolling deadlines with perhaps a fixed deadline for statute of limitations, statute of repose issues. But But I really had clear opinions from the folks who do family law in my district.
All right. What would you all recommend as to our next step in the process of trying to get something on paper that we can return to the Chief Justice with respect to what the suggestion should be out of this group with respect to family law, which it appears to me has in many ways a totally different set of concerns from some areas of practice with regard to our present state of affairs, with regard to the stay that is in effect and the frozen deadlines that we have right now. What do you all think should be our next step in trying to get something on paper?
Well, Your Honor, I would be happy to draft something and send it to Judge Corpening and Judge Vincent, and for that matter, anyone else who would like to review it. I can't promise it by the end of the day today, but I can get it to you by the end of the day tomorrow, if not before.
Well, I think that's certainly the way we need to start. And I appreciate, Mr. Harrison, I really appreciate your the work you put in on this already and your willingness to undertake that drafting. What is the pleasure of the entire group as to how we act in this area?
Well, this is Judge Benson. I would hope.
I'm sorry.
I was saying I would hope that we would also allow for input from the Chief District Court judges that do quite a bit of domestic court or have been assigned to that subcommittee, that we would have the opportunity to give input as well, because we've been discussing what we see as the priorities. It probably would be fairly consistent with what Mr. Harrison has reported from the family lawyers, but I would like the opportunity for us to have some contribution to that.
Okay. Let me interrupt this discussion for just a second. Is Anna Stearns on the line with us?
Sorry, I was muted. Yes, I am here.
Thank you. Anna, of course, we're trying to act on this at the request of Chief Justice Beasley to get information back to her as needed for purposes of any further emergency directives. We had originally talked about trying to get this information back to her by the latter part of this week. Now, she did issue that additional directive late last week. Where does that leave us with regard to any time frame in which our work needs to be done and returned to your office for these purposes?
I think that our biggest concern was just that the current deadline extension is set to expire on June 1st. And so, certainly feel a need to be able to give as much advanced notice to practitioners and to court personnel as possible about any possible extensions. I expect that by the 1st of next week, if we haven't by the end of this week, we will start to hear increasingly frequent questions from the practicing bar about what the plan is for June 1st, because folks want to know whether they should be, planning to file all of those pleadings that day or not. And so I think our goal is just to be able to give as much notice in advance of June 1st as possible. But we are also mindful, certainly, of the need to do this in a way that is thoughtful and considered. And so if you need another couple of days as a group to settle on that exact language and we wind up not acting on this until midweek next week, that is certainly, going to be absolutely fine with us. And we apologize for the need to have to press so hard right now to get this done quickly, and just appreciate everyone's hard work so much. And I think as long as we're moving forward in the way that we are right now, I certainly don't have any concerns about it taking a couple of extra days to get it right. We got to get it right.
Your Honor, this is Elisa Chingary in Mecklenburg County Clerk's Office. I don't think we've weighed in as it relates to our position in criminal or family law. Clerk Johnson, you can join me, but our conversations have been that we are supportive with moving forward June 1st. We understand that it will be a lot of work for the clerks to absorb, regardless of whether it is rolling deadlines or setting it immediately for June 1. We will have asked and will continue to ask for the patience of the legal community as we have limited staffing, but we are poised to attempt to do our very best at processing the work.
It appears to me that we, up until this point, we've been talking really in terms of goals and policies and what we hope to accomplish, but we've got to get down to actually doing the work of drafting to return a work product to the Chief Justice. That's my concern, is how we actually go about doing that.
Judge Bridges, this is Kinsley Craig on behalf of the court managers. We did not submit a written report, but I do have a couple of suggestions or at least recommendations. As far as our group is concerned, many of you know that we have a very unique makeup in that we represent various and different types of court statewide. But as you can imagine, having a unified response or recommendation is somewhat difficult based on those things. But with that being said, we obviously would support the decisions and recommendations made by any district court or superior court judge within this task force. But the points that we have received from some of our working groups would be that we support moving forward and ending the June 1st deadlines, mainly to help prevent an influx at one time. Maybe a suggestion would be stagger the deadlines in a way where, like the first 2 weeks, or the last 2 weeks of March, set a deadline for that. So for instance, like March 16th through March 31st, make that January 30th. The first 2 weeks of April, April 1st through April 15th filings, or that time period deadlines, put those on July 15th. And then the last 2 weeks of April, set a different date for that. That was a suggestion that came from a member of our work group. I think that would be at least a starting point or a way of thinking about it. But obviously the main concern with our group is for clarity's sake, because, in addition to the clerk's offices, our offices and staff typically get a lot of calls also seeking clarifications of orders that come through. So those are just a few points that our group had. Apologies that we did not submit a written report, but that is a brief summary of some of the responses that we received.
This is Marcia Johnson, president of the Clerks Conference, and we did not submit a report either, but I do have a verbal report, and I will give that to you if you're ready for it now, or if there's another. You're okay. All right. I think the one thing that everyone on this call and on this task force can agree is that the common denominator of all of these different aspects of court is the clerk's office. We handle all of that as far as the scheduling, the work, the product, the paperwork. And I think that it's important to note that we are not fully staffed, and more than likely we will not be fully staffed until at least sometime after June the 11th, because that's when the administrative leave policy that was in place will expire. So when decisions are being made about when to open and these deadlines, we need to make sure that the partners in each county, consisting of the Superior Court judge, the district court judge, public defender if there is one, and the clerk and the district attorney, that they work together to make sure when they're setting these courts that they've got staff sufficient from the clerk's office to handle the courts. I think that it would be very important for the Chief Justice to consider really making it very important for everyone to continue to file as much as they can by mail. My office and others have continued to take filings, and that's going to help us as far as the workload when we do start back. And also the remote hearings. That will be a whole lot easier on the clerks. And also, because of social distancing, we will have issues with spacing. So for clerks' hearings, we possibly are going to need a courtroom because some clerks don't have hearing rooms large enough. So two things, the partners need to make sure that the courts can be staffed, and they also need to make sure that there is room in the courthouse to have the courts that they desire to have. And I think that it would be important that if the Chief Justice could communicate the logic to all of the partners, the Superior Court judges, district, and all those I mentioned, to make sure that they work together and why, in order so that we can continue. We do feel that a soft opening, June 1, it could be workable, but like I said, we definitely are not going to be fully staffed then. But we read what the district attorney's recommendations are, and we pretty much are in agreement with that, other than sometimes we think maybe the dates for these may be a little close together. But the only issue we had about the extensions and the different deadlines, when asked the clerks that were in our meeting about having different deadlines, rolling deadlines, I will say that they were against that because it is going to be a problem for the clerks. We get the majority of the calls, not only from the public, but also from the attorneys, and we feel that these rolling deadlines can possibly cause errors, and it's going to cause a lot of calls to the clerk's office. So basically, we didn't agree with the rolling deadlines. We thought a firm deadline would be better, with the exception of summary ejectments. And that's something that we feel like should go ahead and be processed as soon as we could. And that basically, on the deadlines and extensions, is the clerk's report.
There was part of what you just said that I did not hear. With regard to summary ejectments, you feel that what?
We feel that that should have a different deadline, and I'll let Ms. Chingari speak to that.
Thank you, Clerk Johnson. The landlord-tenant statute, particularly 4228, requires that the clerk issue a summons and set a court date within 7 days of issuing that summons. If someone were to file on June 1 with a backlog that is available in most counties, 95%, if not more, of clerks would be in violation of that statute. So we think that for the sake of uniformity and clarity and having a universal compliance with the law, adjusting that 7 days to something that's more realistic for a limited period of time would be advantageous for the entire court community and those that we serve. 7 days also impacts and triggers the execution of that summons, the service and perfection of that summons, and we know that our law enforcement also has a large role in that. So in order for the clerks to be able to comply and our services of processors, which is generally the sheriff's office, have the ability to meet those statutory guidelines, we think that that should be elongated. It's one particular statute In terms of verbiage, it would not be complicated to simply change 7 to something that's more realistic.
And what would that more realistic date be? Or number of days, I'm sorry, not date, but number of days. Would it be 30 days rather than 7?
I can tell you that we have the opportunity to compare and contrast a small and large county on our call. A small county indicated that they felt as though they could be in compliance within a 2-week period. So that is generally 14 days. I am represent the opposite of that continuum. And I would pose a number of 60 days.
Are there special concerns of the clerks also with regard to the status of foreclosure proceedings that have been stayed by this situation?
I think, and it depends on the size of the counties. In some counties, they only held the hearings on certain days, so they will just increase the days that they actually will do the hearings. But I did not get any feedback from the clerks that were on our committee as to concerns about foreclosures.
And if I could add to that, I think that is contingent upon having a courtroom to perform the foreclosures in compliance with social distancing. So if we have that available to us in districts, then we would be on course to maintain the statutory timelines around foreclosure.
And that's going to vary from county to county, because some counties, in my county, we do them by appointment. And so we don't bring in everybody for a calendar call for it, but it varies from county to county.
Mm-hmm. Mm-hmm. Okay. So, and what I hear the clerks saying in this regard, if I'm understanding correctly, and maybe some of us, or at least I had gotten an impression in our earlier discussions, that one of the concerns about extending deadlines to a specified date might create an avalanche of filings for the clerks. But now I hear the clerk's report as being more a concern about the confusion that would likely arise from a series of rolling deadlines as being more of a problem than the potential avalanche of filings, so long as we encourage people to go ahead and resume with their filings sufficiently in advance of whatever that specified deadline is. Is that correct? Is that accurate of what you're saying to us?
Yes, I think when we had our conversation with the other clerks, we can handle the crowd of people coming in with filings. We feel that can be handled a little easier than all the phone calls and the possible errors that are possibly going to happen whenever there are so many different deadlines. And a lot of clerks' offices have already been taking their filings all along. And those will not find it as difficult when we do start back.
And if I could emphasize, as Clerk Johnson already has, then that we'd like to encourage the bar community and to mail in those filings. We do not want foot traffic, an avalanche of foot traffic in the courthouses as people attempt to meet a deadline. We're asking them to prepare accordingly to mail those to us so that we can give integrity to the post date of those mailings. I think that's critical, and I want to emphasize that, because that is in part that is part of the reason, a big component as to why we can be compliant. We don't want the avalanche of people coming to the courthouse, but we will accept those mailings.
All right, so the recommendation of the clerks will be to set a specified date for new deadlines to encourage filings as much as possible by mail, to encourage remote hearings and the availability of courtrooms, but then to take a particular look at the burden imposed by the 7-day rule under GS 4228 and for the Chief Justice to grant some relief under that situation by extending that term to possibly 60 rather than 7 days. Is that correct?
Yes, that's correct. And the only thing I heard that you did not include in that summary was our request that other key court officials consult directly with the clerk as they began to reschedule court events and have specific knowledge of the staffing level in any particular district. As you can imagine, the clerks make up the largest body of judicial employees in our branch. We will have varying staffing levels in every county. We expect absenteeism. So staying in contact with the clerk and understanding the staffing is a necessity.
All right. All right, thank you, ladies.
Judge Bridges,
Yes.
this is Anna Stearns. I wondered if I could just ask the clerks whether there would be any concern as judge of probate for estate administrations, trusts, and guardianships if for the existing June 1st deadline to be applicable as a hard date. And then secondly, to ask whether there is any concern. I'm sorry, I lost my second question, but is there any concern with the existing June 1st deadline for estate administrations and other probate matters?
I will speak to that, Marcia Johnson. The problem will be with June 1 is that the administrative leave doesn't expire until June the 11th. So very short-staffed until then. So that would be the only concern that I would have would be with the June 1 date is that there's going to be very limited staff there.
Okay. My other question was whether there would be any concern with having different deadlines applicable to different practice areas. So if we were to say for estate matters that deadline is now June 12th, and for criminal matters it's July 31st, and for summary ejectments the deadline is June 1st, but we're going to allow the clerks some additional time to schedule hearings. That kind of mixed approach. Are there concerns with the confusion, the same kind of public confusion you noted with rolling deadlines resulting from that kind of split of types of filings?
We did not discuss that particular type of deadlines, but from my personal, I will say, if you want to go to different deadlines, if you did them estates, family law, if you had them by types of law categories, we can work with that better than we can pulling out different types of filings within a particular type of law. Does that make sense? We can work with estate have a particular date or family law has a particular date. I think that the clerks, if you're going to do a rolling, it would be better if it was specific to a particular type of law.
Thank you, ma'am.
So it's easier to work with categories of cases than it is to have to pull the individual case file on every single case and calculate what a new deadline would be based on flipping through dozens of pages in the file. I can see how that would be extremely time-consuming to field questions.
That's right.
For the clerks to have to deal with that. Okay.
Judge, this is JD Keister. Just thought I would also chime in from the North Carolina Association of Defense Attorney perspective. And I think, absent Mr. McCabe telling me that I'm stepping on his toes as civil lawyers in general, I think we're aligned a good bit with Mr. Harrison and the family law group. From our organization's perspective, we do not want to see an additional extension or do not at least see the necessity of an additional extension from our organization's point of view. We do understand, Judge, especially as you stated last week, jury trials are civil jury trials are going to be an impediment both from a safety and social distancing perspective, as well as the priority in terms of what needs to be addressed by our court systems to begin with. But I think civil litigators in general are interested in dealing with the other 93% of cases that don't go in front of a jury and trying to get those moving as much as possible. In terms of the one area that we would like to see, if possible, perhaps a little clarity is on discovery itself. I believe that Chief Justice Beasley intended that the extension of time period encompassed written discovery, and that emergency directive number 1 encompasses depositions. But I think we've had some folks that maybe took a different interpretation of those, and I think that's something that our membership would like to see addressed in any further emergency order or in a clarification of the existing order. Our membership is, we will be sending out something to our members, encouraging them to file prior to whatever the filing deadline or deadlines may be. One additional thought or suggestion is that until we get into around June 1st, we have a lot of our attorneys that are working in a different location than the paralegal secretary or staff member that may be handling the mail or filings, and whether an electronic signature may be a temporary relief mechanism to allow for attorneys to more freely file, still in paper form, but not having to have the attorney in the same location as the staff member, which at least for our firm, we've got most of our folks at home, and I think a lot of other firms that do now as well until we enter probably phase 2 of the governor's plan.
Let me ask, with regard to discovery and the question you posed concerning discovery, what would your group propose the language should be with respect to, in effect, kickstarting those discovery periods again? We're talking about basically carving out 2 or 3 months of time that will have expired during which discovery otherwise could and would have been done. So how do you propose that lost time now be addressed?
A couple things, Judge. First, I think a lot of our members have been moving the cases forward through discovery as best as possible. I think the plaintiff's bar and the defense bar on the civil side of things have worked together to try to make that happen. So I don't know that backlog exists as much as on paper one might think it would. My suggestion would be that, assuming my interpretation of the order is correct, that Justice Beasley did intend for the order to include discovery, then as the extension of time period expires, then we know we're going to have written discovery come due. And then whatever emergency directive ends up being, so that's the dealing with court appearances. I envision that order saying something to the extent of whatever the date may be, Judge, of having that say something to the extent of hearings, court appearances, depositions can move forward if in a safe and social distancing manner or by mobile video conferencing technology. The issue that we're having right now, that I think all civil litigators are having, is the question of whether one can force a mobile deposition right now, or whether that's something that requires consent under, as is currently stated under Executive Directive Number 1, whether in-person depositions, if social distancing is allowed or is acceptable, whether those can move forward by the middle of June. I think that's where the civil litigators are looking for some clarity.
If we start out with your first point that civil litigators do not necessarily want any further extensions beyond the presently existing deadline of June 1st. So if we start with that proposition and the current deadline of June 1st remains in effect, then aside from the other question you've raised about electronic signatures and depositions done remotely without consent, are there other issues that would need to be addressed with regard to civil deadlines?
I'm doing some stuff in the yard. I'm not dressed in uniform. Let me double check this. Let me scroll through.
I'm having a little trouble hearing.
Yeah, I didn't know if somebody was responding there, Judge. In terms of filing deadlines, I do not anticipate, at least from our perspective, that there would need to be anything specific addressed. I think there are certainly going to be some court-imposed filing requirements, things that may be part of a discovery plan, expert designations, things of that nature, that our lawyers should be able to handle on a one-on-one basis with the court via motions practice. And again, with the idea that there be deference given to those reasonable requests that, which has been the order set forth thus far. But no, from my perspective, and again, for a little bit to Mr. McCabe and his group, I don't see any filing deadlines that would need to be addressed beyond June 1. Obviously, the hearing and trial issues, the court appearance issues, are a different animal altogether until we figure those out. But from the filing perspective, I think we'd be good on June 1. John, got anything?
Yes, thank you, Your Honor. Thank you, JD. Your Honor, we agree with what Mr. Keister has proposed. We see no reason for any further extensions of the deadlines with respect to statute of limitations, filing, and in particular, discovery. Our membership very much would like to have discovery continue. It is also our understanding that the Chief Justice's order did apply to all forms of discovery, written or depositions. And we would like to see those cases, just like Mr. Harrison said. I don't know if there needs to be much of a carve out for family law to the extent it aligns with civil, because we're basically wanting the same thing he is. One issue would be depositions, because I do think that's a slightly different creature. Our membership would love to have some provision that says the remote depositions are permitted and or may be done in person so long as social distancing requirements are complied with, just so we can keep these cases moving. I know a lot of our members by consent have been able to do these depositions. They've been able to do them successfully. They've been able to do mediation successfully. That's why I wasn't on this call last Friday. But we agree with Mr. Keister across the board that we see no reason to extend any of the deadlines from a civil practice.
Judge Bridges, this is Kelly Myers, the TCA in Wake County.
Ma'am.
And I wanted to echo the input provided by both civil attorneys just now, Mr. McCabe and Mr. Keister. We received, I think, pretty resounding feedback from at least our Superior Court subgroup that I recall, that they are not in favor of further extending these deadlines for the same reasons, that we can handle a lot of this by a local motions practice. A lot of the deadlines that, mediation deadlines, dispositive motion deadlines, all those we can handle locally with a quick WebEx hearing. And then also possibly encouraging, if we don't extend the deadline, encouraging the use of WebEx by judges to actually deal with these more emergent protective orders prior to depositions, just to help the attorneys get things moving along so they don't have to wait several weeks to try to get on a motion calendar to have something like that heard.
All right.
Judge Bridges, this is, hi, Judge Bridges, this is Ann Anderson. May I just make one comment?
Yes, ma'am.
Thank you. I defer obviously completely to the comments made by the representatives of the civil bar with regard to further extensions of any existing deadlines. So if June 1st is the number, then that's the number. The only thing I would interject is it is the nature of a group like this that self-represented litigants are not represented generally in this group of lawyers and court administrators and clerks. And so I just would say one very minor point for discussion of whether it would be appropriate to extend just statutes of limitations in civil cases for 15 days or some appropriate amount of time for those self-represented litigants who haven't been able to consult with counsel or find counsel or otherwise get themselves out of their houses and away from their kids, just in the interest of general justice. I'm not making a plug for it one way or another. I just wanted to raise the point because they're not otherwise represented on this call. And again, I'm only talking about statutes of limitations at this point. Thank you. And I'll go ahead and remute.
Hey, Don, this is Waylon Sherman's confirming what Kelly Myers said and kind of what Ann said. We really think it's a completely different animal, a statute of limitations or something that is kind of a drop dead. Only the chief could do or something, but we think there's differences there. But as far as the regular deadlines, I think most of us kind of felt like there didn't need to be much extension at all for those. So,
Your Honor, this is John McCabe chiming in back again after Judge Sermons. If there is going to be any extension of the statute of limitations, I'm 100% sure our membership wouldn't have a problem with that. It has created some heartburn among our members that the language in the order does not specifically state statute of limitations or statute of repose.
We talked clearly about that, John, that they were the two things. We had some other kind of sub-issues, deadlines like estates and deadline for claims, all those things, but that'll be clearly enunciated And we talked about like a 30 or 60 or 90-day extension from the June 1st and just as to those statute of limitations.
Thank you, Your Honor. That's great.
Judge Bridges?
Yes.
It sounds to me like the discussion has sort of rolled around to a situation where we're really talking about not extending the deadlines for civil matters, at least, except for a couple of exceptions involving estate matters and perhaps collection matters. So would it still be something that would be either necessary or desirable for me to attempt to formulate a list of the family law claims that still be relevant, or should I turn my attention to something else?
Well, it may not be, Mr. Harrison. Let's see if we can try and reduce this to, if we can define what has come out of these conversations. Based upon the notes I've made, what I've heard from the criminal section is a proposal that there be a new extended deadline for all motions or other filings that are required in the criminal courts to be Friday, July 31st. So essentially a 1-month extension from the presently existing deadline. Then we heard from the civil area of practice that with the exception of the hard deadlines such as statute of limitations and statute of repose, that the civil bar seems to be satisfied with no further extensions. But then we talked about the possibility of extending those hard deadlines for simplicity purposes. Then would it make sense that we choose the same date as a new deadline for those statute of limitations and statutes of repose as the new deadline for filings in criminal courts of Friday, July 31st? Would that make sense?
I think it's clear.
Then, if we said that as to other deadlines, pleadings, or responses that were due in cases, and with regard to discovery deadlines or proceeding forward with the civil cases, subject to the authority previously existing with the local judges to grant additional extensions based upon the showing that's required under existing law, be it for good cause shown or in the exercise of discretion, that those deadlines would then expire as previously ordered, but no sooner than June 1st, 2020. Is that more or less an accurate statement of where we would be as to other aspects of the civil practice?
This is Wade Harrison again. I think that's right, except there was a concern by the clerks about a couple of their proceedings, perhaps in estate or debt collection law, that probably need to be addressed.
So then we need a special provision to address summary ejectments for the clerks with regard to the period of time in which under GS 4228, what would otherwise be a 7-day limit on issuance of summons and setting a court date, to extend that up to 60 days in order to accommodate that situation, right? Have I missed anything in that regard?
No, that is exactly what we said. That's correct. Thank you.
All right.
Kelly Myers from Wake County. We had a comment from one of our court managers that I just want to bring to attention and ask if so Rule 2 of the I think 2B of the General Rules of Practice requires that civil calendars are published and distributed to no later than 4 weeks prior to the first week of court. And so right now, I mean, I know that would mean we would need to be publishing a calendar if we're not going to extend deadlines. And when we sort of talk about getting back to fully operational, we would need to be putting out a calendar for like June, 1st? We should have put that out yesterday. But I don't have anything on the calendar for June 1st right now because people don't know if we're going to be back in court. So I would just ask if that could somehow be stayed, or that 4-week recommendation sort of be stayed right now. I don't know.
Okay.
How about just reducing it to 15 days ahead of the court session, Kelly?
Yeah, I think 2 weeks is fine. That's sort of what we've been trying to do, but since the rule requires 4 weeks, I just don't know how we would. I mean, that means next week I have to put out a calendar for June 8th, and we kind of don't know yet what we can even do on June 8th.
How long would we need to keep that rule in effect, Kelly? Because is that something that would need to be done throughout this transitional process until we get back to normal operations?
No, I don't know. My gut is probably yes, but I don't know how the bar feels about that. Getting their calendar 2 weeks out.
And Judge,
The notice requirements and the rules of civil procedure for motions, I'm thinking about non-consensual court dates, where people notice matters under the rules and say, you know, I've got to have this heard. That is going to be a rub, even though 15 days is still longer than some of those notice requirements of 10 days.
Exactly. Yeah.
and this is Anna Stearns. I will just add that by statute, the Chief Justice's emergency directives expire every 30 days. And so there will be a need to reevaluate any emergency directive like that would, waive the requirement under the rule or reduce that requirement for a temporary period of time. That we would be evaluating that, roughly every 3 weeks in anticipation of the next extension order.
And let me just tell you the reality of calendars and posting and having court now. There's not a person that's gotten a calendar out in the time 30 days ahead of advance in any criminal matters we've done. And we're doing the best we can, but that's just not a real concern because everybody's being called and it's mostly everybody coming on in because they want to get stuff done.
Right. Now, I've enumerated 3 or 4 items to address with this, but that brings me back to the request from the clerks of asking the Chief Justice to communicate some reminder type issues, encouraging the bar to mail filings to the fullest extent possible so as to reduce traffic in the courthouse, and they to encourage communication and cooperation among court officials with the scheduling and availability of courtrooms. To continue doing remote hearings to the fullest extent possible, to reduce the population in the courthouse and reduce the demand for courtrooms. So we want to have those items included. what other points would need to be addressed with regard to these deadline issues?
This is Marcia Johnson. One thing I might mention, as the judge of probate, the clerk has the authority to make any extensions of time within her discretion, and that may be something that the Chief Justice would want to emphasize. And also, you mentioned that if the Chief Justice could communicate cooperation with the partners as to courthouse staff, space. We also need to include, there need to be conversation between the partners as to courthouse space and the staff.
Mm-hmm. Ms. Johnson, would you and Ms. Chingary be willing to draft those items that you enumerated in the language that you would like to see used, or at least examples of language you would like to see used by the Chief Justice in communicating those points in future directives? Would you all, could you all put together a draft of the language you would like to see in that regard?
Yes, sir, we will do that.
Okay. Thank you. Have we overlooked any aspect of the deadline extensions that need to be addressed? Is there anyone else that would like to weigh in on any of these issues? All right. So next becomes the question. I'm sorry.
This is Kinsley. I'm sorry. I couldn't get my mute undone quick enough. One thing that I did receive was court staff sent me some information from the business court, and I'm not sure if you all in Superior Court with the judges have had conversations with that particular group, but one of the responses that I received was that the business court requests that deadlines not be extended from 6/1, that they be extended from 6/1 so that way discovery can proceed, pending motions can be heard, briefed, remote hearings can continue, and that type of thing. I just wanted to make sure that there was some sort of business.
I've emailed them back and forth with them, and that goes along with the general feeling that everybody else doesn't want to extend the deadlines either.
All right. Well, it sounds like we have identified the areas that need to be addressed. Do we generally have agreement then as to those points to be addressed in a communication back to the Chief Justice concerning deadlines?
This is Wade Harris, and I agree, Your Honor.
This is John McCabe, Your Honor.
Would you care to make that in the form of a motion? So, Mr. Harrison, is that a motion? And Mr. McCabe, is that a second?
That's it, Your Honor.
Okay. Then at this time, I'll turn the meeting back over to Judge Corpening, and he may want to call for a roll call vote on that point.
Great. Thank you. And thank you, Judge Bridges, for facilitating that discussion. I obviously picked a great meeting to host since you did all that. So thank you for that. So we've got a motion that's been made and a seconded. Any discussion on it?
Well, this is Jennifer Harjo. Can I put an issue up for discussion in that all this sounds fantastic, and as we start to open up our businesses and start to open up our courts, that's going to be wonderful unless things go awry. I mean, you know, and I just don't know. I mean, I look at the news and I see, you know, positive reports, and then I see negative reports. And right now, as we start to interact more often, I don't know if the number of cases and the number of deaths are going to increase or decrease, and that's my concern.
So Jennifer, this is Jay Corpening. I'll share that on the agenda for next week, Judge Bridges and I have already talked about looking at the type of opening we have on June 1 with priority for cases, for case types, for creative scheduling, to be able to address safety concerns. We're going to have a little bit of time to talk about safety concerns today, but all of this discussion has been about filings. We're going to have another discussion about what it looks like when we reopen, and it may be different all over the state, but we're definitely going to talk about that at our next meeting.
All right.
Any other questions or discussions? Hearing none, then roll call vote. Emily, if you'll call the roll. Aye in favor, nay opposed.
Judge Bridges,
Aye.
Judge Corpening,
Aye.
Judge Sherman,
Aye.
Judge Vincent,
Aye.
Mr. West,
Aye.
Mr. Evans,
Aye.
Clerk Johnson,
Aye.
Clerk Chingary,
Aye.
Kinsley Craig,
Aye.
Kelly Myers,
Aye.
Jason Cheek,
Aye.
Jennifer Harjo,
Nay.
Mr. McCabe,
Aye.
Mr. Harrison,
Aye.
Mr. Weed,
Aye.
and Mr. Keister.
Aye.
That's all members. Judge Corpening.
Right. Thank you. The motion passes. Thank you, everyone, for your input on this. Now we need to address the mechanics of how this goes on paper, is my communication from Judge Bridges. So perhaps staff can step up and draft something consistent with the discussion. I know that Danielle's been keeping copious notes and others have too, and then have it reviewed by the group. Judge Bridges, your thoughts on whether that would cause the need for a second vote?
Yeah, that was a question I've just posed to Judge Corpening. I've sent him a message as we were going through the roll call vote, and my question is, does this body feel comfortable enough with our discussion and then simply asking our support staff to draft language consistent with the discussion we've had, or in the alternative, does the group feel that we need to take another vote once we see the words on paper?
Comments from anyone?
This is Kelly Myers. I don't necessarily know that we need another vote, but I would like to see the words on paper probably as a draft. And then if you start getting a lot of feedback that doesn't accurately reflect maybe what we thought we said, then maybe we do need a vote. It's sort of wishy-washy, but I would like to see the words down in paper before they go.
This is Kinsley Craig. I would echo Kelly's comments. I would prefer to see it on paper.
This is Judge Vincent. I would prefer to see it on paper as well.
So, Judge Bridges, if you disagree with what I'm about to say, please weigh in. But then I'd suggest that we have staff draw up a document that expresses what's just happened. Judge Bridges and I will welcome your feedback, and if there is concern, then we can revisit it with another vote to clarify those concerns. If there are no concerns, then I think we're set on this, but if there are concerns, then certainly we want to circle back and address those concerns.
I agree. I think that's the way to proceed.
All right, then let me turn to Anna for just a minute. Anna, this is Jay Corpney again. If there are no concerns, then clearly we'll be able to send this to the chief pretty quickly. If there are concerns, is there a deadline for when you would want us to meet to at least vote on that again?
I mean, I would hate to call it a kind of special meeting of this group of very, very busy people specifically for the purpose of voting on those recommendations. But I do think if it's possible for us to get it entered by the end of the week this week or Monday at the latest, that really would be preferable so that we can kind of communicate to the public by Monday what's coming. I think that was the original deadline that that Judge Bridges and I had set out for the group in our first conversation as a target, if possible, to have it done by Monday. So perhaps even a short 15 or 20-minute meeting just for the purpose of voting on that on Friday, if the revisions can be made by email. And I think I would just take a moment to remind everyone that while this meeting is being live streamed and is subject to public access, in the same way, emails among the group will be treated as a meeting, and any communications among you will be public. And so just be mindful of that as you're putting your words down on paper and cursing the staff for their efforts to capture all of your comments.
This is John McCabe. Is there any opposition to doing a vote by email?
No.
I support an email vote if that's possible.
Any other opposition? Any opposition at all to an email vote if we need to vote again? And if we vote and if we circulate it on paper and we do an email vote, it's very simple to do that. Judge Bridges, then what I would suggest, I think, is that we get staff to draw the document, share it, welcome input, and then just to avoid any concerns, do an email vote.
Okay. I concur with that idea.
All right, then that's the plan. Danielle, I know you're on the call. Any chance that we could have that document sometime tomorrow to circulate?
Me?
Daniel Carmen, yes.
There is a chance. I will do my very best to make that happen. I might need some additional assistance from our general counsel's office, but I'm happy to do that.
Great. Thank you. And then as soon as we get it, we'll share it with the group, set a time for sharing any concerns, and then ask for email vote. If that meets with the group's approval. That's a plan then. Wow. We have some other agenda items to talk about today. It's 3:48. Judge Bridges, why don't we use the remaining time that we have to go to the reboot, for lack of a better way to put it, of our work groups, and use that time to clarify that and clarify who's involved on the groups. Since we've got about 12 minutes left in our schedule, or 11 minutes left in our scheduled meeting.
Okay.
All right, so last week we came up with some ideas of work groups, and different folks volunteered to serve on the work groups, and we actually, Judge Bridges and I, in talking in the intervening time have thought that we would change the composition of those working groups a little bit. We had a best safety practices and innovation working group, and we felt like we needed to have a best safety practices working group standalone committee, and that court innovations should be grouped with technology. And so we've got the proposal to have these three working groups that now you can see on your screen: the best safety practices working group, the virus fatigue working group, and technology and innovation working group. Some of you had volunteered for what was the best practices and innovation working group, specifically, I think, because of the innovation tag. And so Judge Bridges and I need to know if you're interested in shifting to a different working group. That would be helpful for that. We're also, willing to have some folks that are not part of the task force participate in these working groups. For example, Chief Judge Charlie Brown from Rowan County is heading up my working group within the Chief District Court Judges Association on technology, and I've asked him to provide input on this one. And we've got a specialist in resilience who will be working with Jim Drennan's committee on virus fatigue. So from the membership, anyone want to jump ship to a different committee? Certainly respect that. Anyone who did not get a chance to sign up for a committee want to join up and help with any one of these three working groups?
Teresa Vincent.
Judge Corpus.
I'd be willing to help with the virus fatigue working group. Excuse me.
So I couldn't tell. That was Judge Vincent, right?
Judge Vincent, yes. Thank you.
Thank you.
Judge Corpening, this is Kinsley Craig. If you wouldn't mind adding my name to the technology and innovation section that I see on the screen in addition to Kelly Myers.
Absolutely. Thank you, Kinsley.
Your Honor, this is John McCabe. I would also like to be on the technology working group, please.
Thank you.
Judge, this is JD Keister. I sent Kelly an email last week as well. I'm happy to help out on that technology and innovations work group, or if you need me somewhere else, I'm happy to do that as well.
Thank you. Glad to have you do what you'd like to do. Thank you for your help.
Judge Corpening, this is Danielle. I just wanted to also mention that we do not have a chair assigned for the Technology and Innovations Working Group. So just ask that you and Judge Bridges designate that to someone at some point. Thank you.
We will. I see that's marked in red for us.
Corpening, this is Kelly Myers. Since I think I'm still chairing the best safety practices, you and Kinsley's going to do technology and innovations. You can remove me from technology and innovations, please.
Okay, thanks, Kelly.
Thank you.
Judge Corpening, this is Elisa Chin-Gary. Our clerk's conference said that we would select a designee to fill the void on the Technology and Innovations Working Group. That is Clerk Ball from Johnston County, Michelle Ball.
Thank you.
Would that be in addition to you, Ms. Chin-Gary, or in place of you?
In place of me, sir.
Thank you. Anyone else?
Can I also ask, this is Danielle again, we think we caught all the personal cell phone numbers on this document and on the roster. Please let me know if we accidentally still have a cell phone number for you and what number you would prefer that we replace it with. Thank you.
Thank you, Danielle.
This is Don Bridges. I'm not sure whether or not it shows up on the copy we have, but I'd also indicate earlier today that I've spoken with Judge Chuck Henry, and Judge Henry has agreed to serve on the Innovations and Technology Committee. Then we also had asked that Judge Alan Bedore from Orange County serve on the Innovations and Technology Committee.
Both great choices.
Judge Corpening, this is Whitney Fairbanks, Indigent Defense Services. I am not on the task force, but I would certainly be more than happy to participate, particularly if I can help with the Technology and Innovation Working Group, particularly on there if there are ways that we can use technology and innovation to help IDS and the courts and the private assigned counsel across the state work together more efficiently.
Thank you, Whitney. We're glad to have you. Anyone else? So if you get off this call and you're moved to really want to join one of these working groups, just let Judge Bridges and I know, and we'll make sure that you get connected. We've got about 4 minutes left, and one of the things that I did not do at the start of the meeting that I should have done was to invite some of our members who were not able to be with us on May 1st to introduce themselves and tell everybody what their role is. Emily, do you have a quick note that would identify which of our members are here for the first time?
I can run that down compared to the minutes from last time, but I don't have a list in front of me.
It's okay. I know that Billy West is joining us for the first time today. He had a meeting with the Best Practices group for the Conference of DAs on Friday. So I'll just ask him to go first and introduce yourself to the group.
Thank you, Judge. It's an honor to be on the group. Billy West. I'm district attorney for Cumberland County. Our biggest city, of course, being Fayetteville. I've been in that position for about 10 years and was assistant DA for Mr. Ed Granis, a longtime serving DA here for 10 years before that. I'm presently the president of the North Carolina Conference of District Attorneys, and an honor to be in that position. And we did have our electeds call last Friday morning, and that's the call that I was on, and Robert Evans certainly represented us well. I also serve as treasurer of the National District Attorneys Association, and that has exposed me some nationally to what DA's offices are doing with this issue. And I would say that what we're experiencing in North Carolina is very similar to what we're seeing across the country. I'm on a couple email chains, and it's actually remarkable how it's, the same issues, same questions that we're seeing here in North Carolina. But it's an honor to be part of the group, and I'll certainly hope to bring whatever I can to the group. Thank you, Judge, for the opportunity.
Thank you. And I think John McCabe was involved in some mediation or something on Friday and is with us for the first time. Do you want to go ahead and introduce yourself?
Happy to, Your Honor. My name is John McCabe. I practice in my hometown of Cary. I have served on the North Carolina Advocates for Justice Executive Committee for the last 7 years, and I'm the incoming president-elect. And I'm thrilled to be working on this. JD Keister and I had the pleasure of doing a joint webinar between NCAJ and NCADA a couple of weeks ago, and it was really a great seminar. Kelly Myers participated on that, and really excited about this group working together to help figure out some problems.
Thank you for your work. Anyone else that I've missed that's on the call for the first time today?
Your Honor, this is Christine Villaverde from AOC. I thought it was important that I reach out to the North Carolina Sheriff's Association, and our liaison has agreed. Sheriff James Clemens from Richmond County, he's on the call today. I didn't know if he wanted to introduce himself.
Good afternoon. This is Sheriff Clemens, Richmond County. Hey, Judge, how you do, sir? Good to see you again.
Same here. Thank you, sir.
Yes, sir. I served last year as a president of North Carolina Sheriff's Association, presently the chairman of the executive committee, and as of January, I was appointed to the President's Commission on law enforcement. So for me, representing the sheriffs of North Carolina, the Sheriff's Association, and the citizenry, it is an honor for me to serve as a liaison to this esteemed group.
Thank you, Sheriff, for joining us. Glad to have you. So we're right at our 2-hour limit here for our meeting. Judge Bridges and I had talked about a next meeting date of next Wednesday at 2 o'clock. That would be Wednesday the 13th at 2 o'clock. Judge Bridges, you still good with that time?
Yes, sir.
We will reconvene this task force next Wednesday at 2 o'clock. One of the main orders of business will be to look at case types and how we reopen and give case types priority. So if there are any other working groups that want to give input on what that soft opening looks like, what kind of case type should have priority and how we go about that, then that would be great input to send in before this. We will attach the input that we got for this meeting to the minutes of this meeting. I got that request during the meeting, so we'll be glad to attach that to the minutes of this meeting so that folks can see that, and we'll have that available. With that, we'll adjourn this meeting and we will reconvene next Wednesday, May 13th at 2 p.m. Thank you, everyone, for joining us today and for all of your hard work. Thank you.
Thank you, sir.
Thanks, Judge.
Thank you.
Thank you, sir.
Bye-bye.